26 of the Rules of Procedure, the petition is referred to a select committee.
Questions. Question 1. The Honorable Tam Yiu-chung. According to the projections made by the Census and Statistics Department, the labor force is expected to increase from last year's 3.59 million to the peak of 3.71 million in 2018 and then decline gradually. Although the Civil Service Bureau is conducting a consultation on the extension of the service of civil servants, there are views that the authorities should formulate a comprehensive strategy to tackle the challenges arising from an aging population and a shrinking labor force. In this connection, will the government inform this Council, 1, of the occupations which are currently subject to a statutory retirement age and the requirements concerned, whether it has compiled statistics on such occupations in relation to the average retirement age in the past 3 years, the number of serving employees, as well as the number and percentage of those employees expected to be retiring within the coming 3 years. 2. Given that senior people of the present age generally have better health conditions than those in the past, and that technological advancements have rendered many occupations less physically demanding than in the past, whether the authorities have plans to conduct a review and industry consultations on whether the statutory retirement age of various occupations will suit the present circumstances, so as to explore whether there is room for upward adjustment of the retirement ages, if they have such plans, of the details, if not, the reasons for that. And 3, whether it has studied and formulated measures to tackle the prevailing challenges arising from an aging population and a shrinking labor force so as to maintain Hong Kong's competitiveness, if it has, of the details, if not, the reasons for that. Secretary for Labour and Welfare. President, my reply to the Honorable Tam Yiu-chung's questions is as follows. 1 and 2. Apart from the retirement age of civil servants, there are other ordinances which also regulate the retirement age of the relevant practitioners, including the Security and Guarding Services Ordinance Cap 460, the Pilotage Ordinance Cap 84, as well as the Education Ordinance Cap 2479. Under the Security and Guarding Services Ordinance, there are 4 categories, A, B, C, D, of security personnel permits. Cat B SSP covers a wide range of security services. Its holders may perform guarding work in respect of any persons, premises, or properties. Cat C SPP is required for performing guarding work which requires the carrying of arms and ammunition. Taking into account the requirements of these 2 types of guarding work in respect of the physical ability and alertness of the practitioners, as well as their social importance, the upper age limits for Cats B and C SPP are set at 65 and 55 years old respectively. The statistics of the holders of these 2 categories of SPP are at Annex 1. Those who have exceeded the upper age limits of Cat B and C SPP may apply for Cat A SPP, which does not have any upper age limit. Holders of Cat A SPP may perform guarding work for single private residential buildings. To ensure navigational safety of non-local vessels within the waters of Hong Kong, the Pilotage Ordinance stipulates that all vessels of 3,000 gross tonnage or over and some other specified vessels, while navigating in the waters of Hong Kong, shall be under the pilotage of licensed pilot. An age restriction is imposed on the relevant work, considering that a pilot must possess normal vision and is mentally and physically fit. In 2013, the ordinance was amended to allow Class 1 pilots beyond the age of 65 to continue to work in accordance with their licenses until the age of 68. The statistics of serving and retired pilots are set out in Annex 2. Under the Education Ordinance, a teacher or principal of any aided school shall normally not continue to be employed if he or she has attained the age of 60 or more before the commencement of the school year. However, the Permanent Secretary for Education may issue to the School Management Committee or Incorporated Management Committee of the aided school concerned permission to continue to employ the teacher or principal aged 60 or above for a period of not more than 1 school year. The maximum aggregate period for which permission may be issued shall be 5 consecutive school years. Please refer to Annex 3 for statistics on teachers of public sector secondary and primary schools. The Education Ordinance has already provided flexibility for SMCs or IMC of aided schools to apply for extension of services for teachers and principals. 3. The Steering Committee on Population Policy, or SCPP, chaired by the CS4A, conducted a public engagement exercise on population policy from October last year to February this year. In discussing ways to unleash the potential of existing population, the consultation document recommends extending working life and helping mature workers stay in the labor force longer. During the public engagement exercise, SCPP received many views that supported extending the retirement age of the working population as one of the major strategies to tackle the challenge of a dwindling labor force. In this connection, the Civil Service Bureau briefed SCPP on the consultation on the extension of the service of civil servants at the latest meeting held last Monday, that is the 23rd of June. SCPP agreed to the proposal to adopt a high retirement age for new recruits to the civil service from a future date and considered that such a move could serve as a model for other public sector and subvented organizations as well as private enterprises to follow. SCPP will follow up on the retirement age limit set in specific occupations, including those mentioned in the paragraphs above, which were imposed having regard to their specific contexts and rationales. The Secretariat of SCPP will invite the concerned bureau to brief on and explain the relevant contexts and rationales with a view to facilitating SPCC in considering and making recommendations on whether follow-up action will be necessary. Having considered the views received, SCPP has identified several public areas in addition to the issue of retirement age, which require follow-up actions to tackle the challenges of an aging population and a shrinking workforce. A list of the policy areas is at Annex 4, and the relevant bureaus and departments will start the internal studies on the above measures and will consult concrete proposals to the SC in due course. Mr. Tam Yiu-chung. For Class 1 pilots, their retirement age has been extended from 65 to 68. Class 1 pilots have an important work to do. How come Cat B SPP cannot be given the same treatment? And why doesn't the Secretary consult the trade directly and instead ask the SCPP to deal with this issue? Secretary. Thank you, Mr. Tam, for your question. Can we extend the retirement age of Cat B SPP? The SCPP has explored this possibility. As I said in my main reply, all bureaus, all relevant bureaus will conduct a full analysis and report and to take into account all the relevant factors. If you may refer to Annex 4, you can see in Para D, advocating longer work hours for a general working population and examining whether there are barriers in the current systems and regulations that discourage workers from staying longer in the workforce. The intention is, through the SCPP, the bureau directors will consult the relevant industries. I believe the Secretary for Security has started its liaison with the Securities and Guarding Services Authority, and the SCPP will continue to follow up on this issue. Dr. N. Jiang. Thank you, President. My question for the Secretary also relates to security guards. There is a great demand for Cat B SPP in the community. There are many vacancies unfilled, and there are suggestions as to whether there can be relaxation of the retirement age of Cat B, SPP, so long as they can pass physical examination. They should be allowed to work until 70 years old. Secretary, will you consider this? Secretary, thank you. As I said, we're aware of this issue, and the Security Bureau is aware of this demand. They will follow up in a timely manner. The SCPP is reviewing the retirement age of all respective trades. We'll see whether there can be relaxation of restrictions. We will follow up in an overall manner. Mr. Andrew Leung, thank you. In part 3 of the reply, I'd like to ask whether there is any study on the challenges brought about by shrinking labor force. The GAPD of Shenzhen would catch up, would overtake Hong Kong, and they have a labor force of 6 to 8 million more than what we have. So I'd like to ask whether there are plans to raise our competitiveness and to enlarge our workforce. Secretary, Mr. Leung asked an excellent question. Because of our aging population and our shrinking workforce, starting from 2008, will drop from our peak of 3.71 to 3.51. So the SCPP will investigate this matter in all aspects, where it had carried out a public consultation, is now analyzing the findings. Now, we must unleash the potential of our existing labor force, and we must attract talents to Hong Kong from high-end jobs to all levels of work, and we have to maintain our competitiveness in the business sector. As you can see from Annex 4, we have 10 policy areas to follow up on. And there is a large volume of work behind each of these. We must replenish our labor force. We must unleash the working potential of women, the disabled, and people who have retired early. Perhaps they can continue to contribute to our economy. So we will adopt a multi-pronged approach, and we will give a report to the community in due course. Mr. Stephen Ho, thank you. As Mr. Tam Yiu-chung pointed out, the Civil Service Bureau is going to consult on a proposal to extend the retirement age of civil servants. Many sectors face this problem of an aging population, and there is no youngsters to take over. For instance, in the marine sector, when you ride a ferry to Changchou, you see that many members of the crew are over 50 years old. So I'd like to ask what the government has done to encourage new blood to join these trades. For instance, when they sit for a Class 3 exam, will there be adjustment to its examination? Secretary, we understand that many sectors face this problem. Regarding navigation, well, we have made a slight progress, and this is rather encouraging. Starting from 2008, our navigational school has been able to recruit 30 new students every year. They are willing to engage in the offshore shipping business. As for midstream requirements, we are using various measures to encourage young people to join this trade. This is not just restricted to the marine industry. We are using a flexible approach. For instance, can there be in-service training so as to encourage young people to join industries where manpower is in great demand? Mr. Pan Xiaoping, as the Secretary said, the SCPP will collect views from different sectors and discuss with the relevant bureaus and departments. There will also be internal studies on these measures and submit concrete proposals to the Steering Committee in due course. I'd like to know whether there is any timetable for submission of the reports of these studies. Secretary, we've just completed the public engagement exercise. through the Social Service Center of Hong Kong, we are analyzing the data. In early July, there will be a report submitted to us and will share with members. Different policy bureaus are studying the 10 policy areas set out in Annex 4. We hope that by the end of by the latter half of this year, we'll have a set of measures, and in due course, we will report to the relevant panel. Mr. Martin Liu, according to the government's report, the biggest challenge is in technicians. Take the construction industry as example. We have many infrastructure projects, and over 40% of our construction workers are approaching 50 years old, and so training will not be able to meet our urgent demand. In the short term, what measures do we have to help this industry? Secretary, we are concerned about the tight manpower situation of the construction industry. We have a multi-pronged approach, of course. We must make good use of our local manpower resources. There can be training or retraining. The CIC and the relevant departments have done a lot. In these past few years, we have trained a few thousands new construction workers. And I think the entry age is getting younger. It's around 30 years old. And in the short term, we have large infrastructure, and we may need skilled workers in drilling of tunnels and more complicated skills required. Under the Hong Kong-Macau Bridge, we have the supplementary labor importation scheme run by the Labor Department. We have already imported 500,000 workers recently through this mechanism. However, in the process, we'll ensure that local employment will not be affected, and will only import the kind of skills really in great demand in Hong Kong. And we have also enhanced the measures, all government projects and public works projects. Now, if we really don't have enough manpower, we can compress the advanced works so that the LAB can approve such applications for importation of labor more quickly. Mr. Liu, I know I understand that it's difficult to amend the mechanism. However, without changing the mechanism, can we simplify the application, the approving procedures? Yes, we have an enhanced mechanism of the LAD. We have not changed the current mechanism. There must be 4 weeks of local recruitment. There must be a shortage of this kind of skills among our local workers. In the past, it took us 6 months to 10 years to approve an application. Now we are able to shorten it to 3 to 4 months to meet the needs of urgent capital works. Mr. Lee Chut-yan, now we're worried that in Annex 4, you will boil down to expediting the importation of labor. Now, in 4, here it says to see whether there are barriers in the current systems and regulations that discourage workers from staying longer in the workforce. What is the outcome of the examination? Air Dragon require their crew to retire at 45 and CX 55 years old. So this is age discrimination, which is one of the barriers. So I'd like to know, what barriers have you identified? Will you include age discrimination? Will you legislate to outlaw age discrimination as a means to overcome these barriers? Mr. Cheung, well, indeed, we have already set out the direction of our review. We are going to examine what barriers we have. Now, if we extend the working age, will labor insurance be a problem? If yes, how do we tackle that? And what about policies of enterprises? We hope that the government can take the lead and be a model. So once the government has extended its retirement age with the appropriate measures, then public and subvented organizations and even the private sector will be encouraged to extend the working age. I'm sure we will be able to be a role model. He has not answered whether age discrimination is one of the barriers. Well, in the manpower panel, there was an in-depth discussion. A few years ago, Mr. Lee, you asked whether we're going to legislate to outlaw age discrimination. Our conclusion is public education, promotion, and change of culture are more important. Mr. Leung Chi-chung, President. I think it is rather confusing as far as the retirement age is concerned. For instance, in the civil service, it is 60, but for elderly welfare, you have to wait until you are 65. As said by the Secretary, we hope that the government will take the lead, and then the private sector will follow in extending employees' retirement age. Will there be a statutory retirement age? Are you going to legislate on retirement age? Secretary, thank you. Indeed, we do not have a statutory retirement age, and individual companies are free to decide their own, and the government also adopts an administrative measure. Will legislation be easy? I think it is rather complicated and may create constraints. I think we should start from a change in culture. We should encourage employers to retain employees that are physically and mentally fit. They can be employed on a part-time basis so that there can be transfer experience to the new generation. This is conducive to the operation of the company. In the long term, should we legislate to lay down the statutory minimum wage? Well, it's a suggestion, and we'll bring it back to the SCPP. We'll spend close to 22 minutes on this question too.
The Honourable Kwok Wai-keung. Thank you, President. Under Section 40 of the Road Traffic Public Service Vehicles Regulations, any taxi driver who solicits business by offering a discount on taxi fare commits the offence of soliciting. Recently, some associations of the taxi trade have complained to me that taxi call service mobile applications with the option 85 have become available lately, and all the taxi drivers registered under that option are willing to offer a fare discount of 15% to passengers. Such associations said that many taxi drivers took risks and used such kind of apps to offer fare discounts to passengers in order to solicit business. As a result, the livelihood of drivers charging legal fares has been seriously affected. In this connection, will the government inform this council, 1, whether it has examined if those who develop and provide the above-mentioned apps for downloading have contravened the law? If the outcome is in the affirmative, whether it's instituted any prosecution against the developers concerned and demanded the developers to remove those apps from the platform of web stores in the past 12 months. If no prosecution has been instituted, how the government curbs taxi drivers soliciting business by offering fare discounts to passengers through such apps. Thank you, colleague, for correcting my Chinese pronunciation of a word. Number 2, given that in reply to a question raised by a member of this council in November last year, the government indicated that the police were following up on whether any taxi drivers were using the apps to offer fare discounts to passengers, of the details of the follow-up actions. Whether police officers posed as passengers in the past 4 months to call taxis by means of the apps for the purpose of law enforcement to combat the offer of fare discounts by taxi drivers. If they did, of the respective numbers of such law enforcement operations and taxi drivers who were prosecuted. And 3, given that the existing legislation only prohibits taxi drivers from offering on their own initiative fare discounts to passengers to solicit business, whether the government will conduct a study on enacting legislation to prohibit fare bargaining by passengers in order to curb taxi drivers offering fare discounts at the request of passengers. Secretary for Transport and Housing. President, the government has all along been striving to assist the trade in maintaining quality taxi service. Taxi operations is regulated by the Road Traffic Ordinance and its subsidiary legislation. The police combat any malpractices vigorously. The Transport Department reminds the taxi trade to abide by the law through close communication with them. TD also disseminates information to passengers through different channels. Members of the public can all along hire taxi service through calling taxi call stations. As smartphones and mobile applications have been gaining popularity, the use of taxi hailing mobile apps is becoming more common. This kind of mobile apps bring convenience to passengers and is by nature no different from the conventional way of hiring taxi service through taxi call stations. While using taxi hailing mobile apps solely for hiring taxi service is not illegal in itself, it is an offense for any person to use such mobile apps to solicit passengers by offering a fair discount. Whether an offender can be prosecuted depends on whether there is concrete evidence. The reply to the various parts of Kwok Wai-keung's question is as follows. Parts 1 and 2. According to the soliciting behavior prescribed under Regulation 40 of the Road Traffic Public Service Vehicle Regulations, any taxi driver or his/her representative who in any manner attracts or endeavors to attract any person in order to induce such person to make use of his/her vehicle without a reasonable excuse commits an offense. The driver or his/her representative is liable to a maximum fine of $10,000 and imprisonment of 6 months. Against the above regulation, any taxi driver who offers a fair discount on his or her own initiative to induce passengers to make use of the vehicle is engaging in soliciting activities, irrespective of whether such arrangements are made through mobile apps, telephone calls, or other means. The government is aware that mobile apps are available in the market for passengers and drivers to arrange taxi service at legal fares. This is not unlawful. Using mobile apps to arrange taxi service is also catching on in other places. However, the arrangement would be illegal if there is any concrete evidence showing that a fair discount option is available through the mobile app for the purpose of soliciting passengers. As the mobile app industry is developing quickly, the apps come in various types, designs, and functions. They also evolve rapidly. Further, it is quite often that only the driver and passenger are present when the incident takes place. All these make it rather difficult to adduce evidence for instituting prosecution. According to legal advice, there has to be sufficient evidence to prove that the mobile app developer or operator or the taxi driver concerned has been deliberately offering a fair discount through the mobile app to attract passengers to use taxi service before the law enforcement agencies can institute any prosecution against the individuals concerned. The police have all along been looking into taxi malpractices through disguising as passengers. Based on information provided by the police, the number of offenders prosecuted for soliciting in 2013 and the first 5 months of 2014 is 156 and 27 respectively. None of these involve the use of mobile apps. The police are concerned about malpractices in relation to taxi service, including those involving the use of mobile apps, and would have to investigate each case to determine whether there is sufficient evidence to institute prosecution. It has to be done on a case-by-case basis. The TD is willing to We're happy to offer advice to mobile app developers and the taxi trade regarding provision of mobile apps that are in compliance with the law. Indeed, TD has recently met some mobile app developers to understand their operation. Further, the TD reminds the trade from time to time not to break the law inadvertently when using mobile apps to accept hire. The taxi trade should not risk infringing the law. Part 3. Taxi drivers and passengers are legally required to charge and pay taxi fares according to the meter. Regulation 47 of the regulations provides that a taxi driver shall not charge more than the metered fare, while Regulation 48 prohibits passengers from intentionally or dishonestly endeavoring to avoid payment of the metered fare. Mr. Kwok inquired whether the government would consider amending the law to prohibit fare bargaining by taxi passengers. The TAC, Transport Advisory Committee, studied carefully whether it would be feasible and meritorious to do this. In 2008, reference was drawn from 14 cities. Most of these, including Tokyo, London, and New York, did not prohibit fare bargaining by taxi passengers. None of them imposed any penalty on passengers for fare bargaining. Even if fare bargaining by taxi passengers was explicitly prohibited, TAC's assessment was that it would be rather difficult to adduce evidence and take enforcement actions is only the taxi driver and passengers will be present when this takes place. The deterrent effect so achieved would not necessarily be any greater than that of the existing arrangements. Further, a number of people might find it too harsh to make a verbal inquiry for lower taxi fares an offense. In any event, taxi drivers can refuse requests by passengers for lower taxi fares under the law. Apart from the above, after the implementation of the taxi fare structure that increases short-haul fares and lowers long-haul fares since late 2008, the fare per kilometer for long-haul trips is lower than that for short-haul trips. Like in urban areas, a journey of 9 kilometers is regarded as a long-haul trip. The incremental charge per jump is $1 after 9 kilometers, while that for each jump below 9 kilometers is $1.60. This fare structure is conducive to reducing the incentive for fare bargaining by passengers and offering a fair discount by taxi drivers. Trade members are also worried that any legislative amendments may reduce flexibility because they will no longer be able to cope with a situation whereby a taxi driver charges a lower fare due to a wrong route or having insufficient change. Mr. Kwok Wai-keung, I have this app in my hands and I can quote from this. Latest news. The law protects the passengers and taxi drivers, and you can open the apps like this, but if you have any other requests, you can open the options. Thank you. This sentence is actually saying that passengers can make use of the apps to request for a discount. Just now, the secretary said that usually there would only be the taxi driver and the passenger during the incident, so it's very difficult to gather evidence. My question is, can you prohibit such apps from providing the flexibility for passengers to make a request for discounts if you only rely on Regulation 48, which prohibits passengers from intentionally or dishonestly endeavoring to avoid payment of the metered fare? I think this is not effective. How can you monitor such apps so that there will not be loopholes for taxis to offer discounts? President, we are aware that in present-day Hong Kong, there are about over 10 such apps for people to hire taxis. If in a certain apps it says that passengers can make extra requests and it doesn't mention taxi fares at all, so there is no evidence that the platform or the developer or the operator or taxi driver is soliciting business by providing a discount. So if there is any particular case, if we should receive information of any case, the police would have to take a closer look specifically to see whether there is evidence to prove that the platform operator or the taxi driver is providing a taxi discount, a fare discount. Mr. Chen Han-pan, President, my question is, the apps are becoming popular. Other drivers who do not offer discounts are affected seriously. Does the government understand this? Do you understand how these apps are used? Do you have an understanding of that? Secretary, President, if the apps is regarded as some kind of latest scientific development to facilitate trade or service provision, we always talk about e-business. That is quite a normal development. The question is whether there are people using such platforms to solicit business. It's just like soliciting business through other channels. From law enforcement angles of the police, you need specific evidence. I cannot disclose or divulge how the police will do this, but I can tell you that indeed the police and the TD are concerned that people are using such apps platforms in order to solicit business in certain ways. But I have reviewed these 10-odd common apps in Hong Kong. Very rarely do they provide the flexibility for passengers to make a request. But as I said, you have to actually look at what request it is. Mr. James To, I actually asked the Secretary to see whether the law can cover this as it stands. The passenger pays 100% taxi fare, but the apps company charges the taxi driver 15% as a fee because the apps helps you solicit the business. And then the apps actually pays the passenger a 14.9% discount in order to buy other products on that webs. As a lawyer, I don't think this breaks the law. Now, I'm not asking you that question. My question for you is, when our law is applied in such cases, is there enough guarantee that the spirit of the law is appropriately and fully respected? Secretary, President, whether our laws can catch up with technical developments and also advancement of the times. Indeed, this applies to all laws, and we have to review them from time to time to see whether the coverage is enough. But coming back to Mr. Chou's specific question, exactly when it comes to law enforcement and hard evidence, we have really to look at each case to see whether how this is done and whether this amounts to inducing or endeavoring to induce people to use a certain taxi service. So it depends on the evidence in each case. The police is concerned and the TD is concerned about this. That is why the TD has more frequently reviewed these apps. But very often the apps can evolve even during the day. If you look at it at different times of the day, it might show you different things, and then very often things are put on the shelf or off the shelf quite rapidly. Ms. Anne Chang, President, I think you're aware that in mid-June in the UK there were 10,000 taxi drivers who staged a protest and a strike. European drivers are now very unhappy about the phenomenon. They pay a high price in order to own a taxi. And some people actually put their entire life savings into a taxi. They might have just paid all the mortgage payments. Mr. Secretary, if someone develops some software or an apps, and then people can download it and hire taxis on the web, then to the taxi companies, the traditional taxi drivers, what protection is there? And also, when taxis are hailed on the web, how can you make sure that they are all licensed? Do they carry the particulars of the taxi drivers? And how can you ensure the safety of the passengers? President, we're aware that in large European cities, including London, that taxi drivers are reacting to such apps. But we have to separate two phenomena. One, using the apps in order to arrange for taxi service. Well, taxi is an adjunct mode of transport allowed under the law, and they charge by the meter. But then the trade, of course, is not unhappy about this arrangement. In fact, they are concerned about vehicles for hire. These are not taxis. They cannot accept passengers or hire without a pre-arranged appointment. They do not have a meter. So first of all, there must be a pre-appointment. And secondly, it cannot charge each individual passenger on board the car. This is prohibited by the passenger carrier license. In Hong Kong, when we issue such licenses, we tell them the regulations. If they breach the regulations and they operate as taxis, then they break the law. Mr. Frankie Yik, President, as members have said, the discount is offered through the app's platform. The taxi driver himself does not have to induce the passengers, so there is difficulty in adducing evidence. However, if you do not crack down on such services in a timely manner, then nobody would be paying by the meter anymore. Mr. Kwok was saying whether you should legislate against fair bargaining by passengers. You said, Secretary, that adducing evidence would be difficult and the deterrent may not necessarily be higher than the arrangements that we have. I beg to differ. If that is the case, then the entire honor system adopted by overseas countries will collapse. Well, it has to do with the quality of the people, of course. In Hong Kong, we are a city with the rule of law. It is our core value. And basically, Hong Kong people abide by the law. As long as you tell our citizens clearly that fair bargaining is illegal, I'm sure the public will follow the law. The Liberal Party conducted a survey recently. 47% of citizens opted for law legislation making, and 38% said no, and 15% had no particular views. So would you consider doing that again? President, I quoted what the TAC did in 2008 in my main reply. At that time, it was a review on the entire taxi trade. At that time, they took reference from 14 major cities. Most of them did not prohibit fair bargaining by taxi passengers. Some did, but without penalties. As I said in the main reply, these cities like Tokyo, London, and New York, they do not prohibit fair bargaining. Neither does Hong Kong. In other words, passengers can make the request, but if the taxi driver is of the view that it will harm his interest, then under the law, he can charge by the meter, and passengers cannot refuse to pay according to the metered fare. If they refuse, they break the law. What is crucial is if the bargaining is accepted by both parties, then actually the meter is to protect the interest of passengers in that reasonable fares should be paid. We also seek to protect the interest of taxi drivers. What the law targets now is soliciting. In other words, soliciting by providing discounts by taxi drivers. If you ask us to take another general look to prohibit taxi bargaining by passengers, yes, we can gauge the view of the trade again, but our liaison with the trade doesn't show that that is popular with the trade. Mr. Yik, what is the problem? Secretary, do you think this is unfair to law-abiding drivers? Sorry, Mr. Yik. This is not part of your supplementary. Mr. Charles Smock. Thank you, President. I support opening up the market for competition. In fact, the apps developing companies actually have the investment from fund companies, and in fact there is acquisition, and the largest such app company is coming to Hong Kong. And also, if there are vehicles that do not need any driver have been developed, then this trade may be a sunset trade. So my question is, President, would the administration actually expressly allowing for fair bargaining by passengers so that there will be a normal environment for the development of such technology? Just now, Secretary, you said you would consult the trade. Would you also consult the technology industries? Secretary, President. We are talking about making use of apps platforms to arrange for taxi services in order to facilitate taxi drivers and passengers. This is just about the application of technology. Our policy is that we have to protect both parties. So paying and charging by the meter would mean protection for both parties. But if the passengers can freely bargain for fare, well, yes, this happens in certain cities, but it is actually not good for passengers because they have to start bargaining once they board the taxi. If the passenger makes the request and the taxi driver is willing because, for example, he doesn't have enough change, then we do not want to target such situations. If we do, we have to make sure that nobody can ever deviate from the metered fare, and it may give rise to certain problems mentioned in the main reply. We have looked at other major cities, and it seems there is no mainstream way to do it, whether, for example, we should expressly prohibit fair bargaining and also to institute penalties. We have spent over 20 minutes on this question.
Question number 3, Ms. Helena Wong.
President, the State Council points out in the white paper on the practice of the one country, two systems policy in the Hong Kong SAR released on the 10th of this month that the central government exercises overall jurisdiction over the Hong Kong SAR and states the following clearly for the first time: supporting and guiding the administration of the CE and government of the Hong Kong SAR in accordance with the law. The CE reports his or her work to the central government on an annual basis on the implementation of the basic law and other items for which he or she is accountable to the central government. And the state leaders give guidance to the chief executive on major matters relating to the implementation of the basic law. The white paper also points out that under the policy of one country, two systems, all those who administrate Hong Kong, including the CE principal officials, members of the EXCO and LegCo, judges of the courts at different levels, and other judicial personnel have on their shoulders the responsibility of correctly understanding and implementing the basic law, of safeguarding the country's sovereignty, security, and development interests, and of ensuring the long-term prosperity and stability of Hong Kong. In a word, loving the country is the basic political requirement for Hong Kong administrators. In this connection, will government inform this council, A, if it has approached the central government to gain an understanding on whether the statement that the central government exercises overall jurisdiction over the Hong Kong SAR implies that it can interfere with matters within the ambit of the Hong Kong SAR's high degree of autonomy? If so, whether the central government has so interfered in the past and how it plans to interfere in the future. B, whether it has studied if the basic law contains any provision which provides a basis for the central government to give guidance on the administration of the Hong Kong SAR government if the study outcome is in the affirmative of the details and the major matters in respect of which the central government guided the administration of the Hong Kong SAR government in the past. And C, as some members of the legal profession have pointed out, that in variance of the mainland, Hong Kong SAR implements a tripartite political system under which there is separation of executive, legislative, and judicial powers with checks and balances among one another, and judicial independence is also one of the core values vital to the Hong Kong SAR's success. Whether the Hong Kong SAR government has relayed to the central government that the implementation of the existing political system in the Hong Kong SAR must be respected and the characteristics of such a system must be safeguarded. If it has the details, if not the reasons for that. President, the State Council published on the 10th of July this year the white paper on the practice of the one country, two systems policy in the Hong Kong SAR, setting out comprehensively the implementation of one country, two systems in the Hong Kong SAR, the major achievements made, the policy measures by the central government to support the long-term prosperity and stability of the Hong Kong SAR and their effectiveness, as well as the long-established basic principles of the central government regarding Hong Kong to help various sectors of the community in having a better and comprehensive understanding of one country, two systems and the basic law. Article 31 of the Constitution of the PRC stipulates that a state may establish special administrative regions where necessary. The systems to be instituted in SAR shall be prescribed by law enacted by the NPC in the light of the specific conditions. Article 62 of the Constitution stipulates the functions and powers exercised by the NPC, including Clause 13, to decide on the establishment of special administrative regions and the systems to be instituted there. It was stated in the preamble of the Basic Law that upholding national unity and territorial integrity, maintaining the prosperity and stability of Hong Kong, and taking into account its history and realities, the PRC has decided that upon China's resumption of the exercise of sovereignty over Hong Kong, a Hong Kong SAR will be established in accordance with the provisions of Article 31 of the Constitution of the PRC, and that under the principle of one country, two systems, the socialist system and policies will not be practiced in Hong Kong. Further, it is also stated that in accordance with the Constitution of the PRC, the NPC hereby annexed the basic law of the Hong Kong SAR of the PRC, prescribing the systems to be practiced in the Hong Kong SAR in order to ensure the implementation of the basic policies of the PRC regarding Hong Kong. The Basic Law is a national law enacted by the NPC in accordance with the Constitution and has constitutional status in the Hong Kong SAR. My reply to the three parts of Dr. Helena Wong's question is as follows. Parts 1 and 2. Article 1 of the Basic Law stipulates that the Hong Kong SAR is an inalienable part of the PRC. Article 2 of the Basic Law stipulates that the NPC authorizes the Hong Kong SAR to exercise a high degree of autonomy and enjoy executive, legislative, and independent judicial power, including that of final adjudication in accordance with the provisions of the Basic Law. Chapter 2 of the Basic Law stipulates the relationship between the central authorities and the Hong Kong SAR, including the powers directly exercised by the central authorities in accordance with the Basic Law, and also the powers delegated by the NPC to the Hong Kong SAR to exercise a high degree of autonomy in accordance with the provisions of the Basic Law. Article 43 of the Basic Law stipulates that the CE shall be the head of the Hong Kong SAR and shall represent the Hong Kong SAR. He shall also be accountable to the Central People's Government and the Hong Kong SAR in accordance with the provisions of the Basic Law. Article 48 of the Basic Law authorizes the CE to lead the government of the Hong Kong SAR, to be responsible for the implementation of the Basic Law, to nominate and to report to the CPG for appointment of principal officials, to decide on government policies, to sign bills passed by the LegCo, and to promulgate laws, to appoint or remove judges of the courts at all levels in accordance with legal procedures, to implement the directives issued by the CPG in respect of the relevant matters provided for in the Basic Law, to conduct on behalf of the government of the Hong Kong SAR external affairs as authorized by the central authorities, etc. Since the establishment of the Hong Kong SAR, the central government has been acting in strict accordance with the fundamental principles and policies of one country, two systems, Hong Kong people, administering Hong Kong, and a high degree of autonomy, as well as the provisions of the Basic Law to support the CE and the government of the Hong Kong SAR in administering Hong Kong in accordance with the law. Similarly, the government of the Hong Kong SAR has also been administering the affairs of Hong Kong in strict accordance with the one country, two systems principle and the Basic Law. According to Article 2 of the Basic Law, the NPC authorizes the SAR to exercise a high degree of autonomy and enjoy executive, legislative, and independent judicial power, including that of final adjudication in accordance with the provisions of the Basic Law. In addition, Articles 16, 17, and 19 of the Basic Law elaborate respectively on the executive, legislative, and independent judicial powers, including that of final adjudication enjoyed by the SAR. According to the overall design of the Basic Law, the political structure of the SAR is an executive-led structure headed by the CE. For example, according to Article 43 of the Basic Law, the CE shall be the head of the Hong Kong SAR and be accountable to the CPG and Hong Kong SAR in accordance with the provisions of the Basic Law. At the same time, Article 60 of the Basic Law stipulates that the head of the government of the Hong Kong SAR shall be the CE of the Hong Kong SAR. As such, the executive authorities and the legislature should regulate each other as well as coordinate their activities. On judicial independence, the Basic Law stipulates that the Hong Kong SAR enjoys independent judicial power, including that of final adjudication. In addition, Article 104 of the Basic Law also stipulates that when assuming office, the CE, principal officials, members of the EXCO and of the LegCo, judges of the courts at all levels, and all other members of the judiciary must, in accordance with the law, swear to uphold the Basic Law of the Hong Kong SAR of the PRC and swear allegiance to the Hong Kong SAR of the PRC. The government and the Hong Kong SAR has been upholding, or have been the Hong Kong SAR has been upholding judicial independence, and the central authorities have all along respected the independent judicial power, including final adjudication of Hong Kong in accordance with the Basic Law. The government of the Hong Kong SAR believes that strict adherence to the Basic Law is the key to the successful implementation of one country, two systems, Hong Kong people administering Hong Kong, and a high degree of autonomy in Hong Kong. Since the reunification, the central authorities and the government of the Hong Kong SAR have been handling the relationship between the central authorities and the Hong Kong SAR in strict accordance with the Basic Law. Mr. Chan Chi-chuen, what's the question? I want a quorum count. Ms. Helena Wong, you may now ask your supplementary question. Now, concerning parts 1 and 2 of my question, they relate to the central government's claim that it has overall jurisdiction over the Hong Kong SAR. Does that mean that the central government can interfere with matters within the ambit of the Hong Kong SAR's high degree of autonomy? The administration answers parts 1 and 2 together, and it keeps referring to articles in the Basic Law, but I don't think the Secretary has really answered my question. So is the understanding outlined in the White Paper correct? Can the Secretary tell me this? Is it that the central government can exercise overall jurisdiction over the Hong Kong SAR? Is it that the central government can interfere with matters concerning Hong Kong's administration? Is it that the central government can give guidance to the Hong Kong SAR? Has there been any interference, and will there be any interference in the future? Secretary. President, last week I answered a similar question raised by Ms. Emily Lau. So concerning Ms. Helena Wong's follow-up question, I want to say that in the White Paper concerning the reference to the central government's exercising overall jurisdiction over the Hong Kong SAR, in fact, there is a second part to this statement. So the central government exercises its powers under the Basic Law, and also the Hong Kong SAR can, in accordance with the Basic Law, enjoy a high degree of autonomy. And so, in my reply, I have referred to the relevant articles in the Basic Law. So the central government can appoint the CE, principal officials, and also concerning political development, the role of the NPC. So these are the powers exercised by the central government under the Basic Law. And then also under the Basic Law, the Hong Kong SAR has been authorized to exercise a high degree of autonomy, and may I refer to Article 2 of the Basic Law. And then in Chapter 5 and Chapter 6 of the Basic Law, there are details concerning the authorization given to the Hong Kong SAR by the NPC to exercise a high degree of autonomy. And so concerning exercising overall jurisdiction, this is in fact the words used in the English version of the White Paper is exercising overall jurisdiction. The Hong Kong SAR is part of the country, and I think I will interpret overall jurisdiction in this manner. Ms. Helena Wong, I think the Secretary is suggesting that members do not know the texts well, so to speak. I want to say that, in fact, all members know these texts well, so I hope that he can withdraw his remark, suggesting that members do not know the texts well. And then I want him to answer my question, and that is concerning matters within the ambit of the high degree of autonomy of the Hong Kong SAR. As stated in the Basic Law, has the central government interfered before in these matters not relating to national defense and diplomatic affairs? Has there been any interference? Has guidance been given? And has the Hong Kong SAR government taken the initiative to approach the central government for guidance and advice on such matters? Yes, President, the CE represents the Hong Kong SAR and is accountable to the Hong Kong SAR as well as to the central authorities, and that's Article 43 of the Basic Law. And the CE has to lead the SAR government, and the CE and the officials in the SAR government have the duty to implement the Basic Law. Since the reunification, the CE has annually reported his work to the central government. So
this is a manifestation of Article 43 of the Basic Law concerning the CE being accountable to the CPG. And in fact, the SAR has been operating in accordance with the principles of the Basic Law and also mutual respect and also a high degree of autonomy, Hong Kong people administering Hong Kong and so on and so forth. I have taken part in the work of the SAR government for many years, and my first-hand experience tells me that concerning one country, two systems, and also a high degree of autonomy, both the CPG and the Hong Kong SAR respect this principle, and this principle has been implemented concerning the relationship between the Central People's Government and the Hong Kong SAR. Mr. Chen Kin-po, in the main reply, it is said that the white paper explains the central government's basic policies towards Hong Kong. As a result, the public can understand more about one country, two systems and the basic law. But then there are people who do not really understand the basic law and one country, two systems. I want to know why at this point in time the white paper is published. Is it because the policy has changed? Because reunification occurred quite some time ago. Yes, President, I've read the white paper a number of times, and my view is that the white paper neither adds to or reduces anything in the basic law concerning one country, two systems. In fact, over the past 17 years, concerning what happened, chapters 3 and 4 detail the SAR's economic development, social development, and political development, and facts are presented in these two chapters. So a narrative approach has been adopted in these two chapters. And as Mr. Chan is aware, the basic law was promulgated in 1990, and next year marks the 25th anniversary of the promulgation of the Basic Law. And so the white paper provides an overview of the implementation of the Basic Law in one country, two systems in the Hong Kong SAR. And concerning how we can further promote the Basic Law, I admit that initially, after the reunification, the SAR government made use of APIs and other publicity channels to explain the two systems. And then out of the 160 odd articles in the Basic Law, most of them detail the arrangements concerning the two systems. In other words, the system to be implemented in Hong Kong. But then, in the past, the emphasis was on that aspect. But then in the past few years, we had 3 rounds of discussions on political development. And so concerning the promotion of the Basic Law, the promotion of one country, two systems, many have suggested that we should promote the Basic Law on a more comprehensive basis. So next year, when we have the 25th anniversary of the promulgation of the Basic Law, we'll see how we can promote the Basic Law in its entirety. Thank you. Mr. Pin Yun. President, according to the administration's reply, both the CPG and the Hong Kong SAR strictly observe the Basic Law. But then you can see that there has been a public outcry since the publication of the white paper. Many are worried that one country, two systems and a high degree of autonomy may be jeopardized. So if one country, two systems cannot be maintained, then I believe Hong Kong people want the SAR government to put their demands to the Central People's Government. I want to know whether the SAR government played any role in the putting together of the white paper. Were you aware of the putting together of the white paper? Did you have access to the text? Did you give advice? And did you know who and which departments were responsible for drawing up the white paper. Thank you. Secretary. Since the publication of the white paper, there have been some comments expressed in society. Some concerns have also been expressed. We've heard these views and we have noted these views. So there are mainly 3 points. First of all, the relationship between overall jurisdiction exercised by the central government and the one country, two systems. And second, concerns concerning the judicial power, independent judicial power. And also, thirdly, the arrangements for the return of the election of the CE by universal suffrage. So these are the 3 main concerns. So I've already responded to the point about the central government's exercising overall jurisdiction over the Hong Kong SAR. I hope I've already addressed Ms. Wong's concerns. And then concerning judicial independence, the S4J has immediately stated the SAR government's position and has tried to allay public concerns. And then concerning political development, not too much content is found in the white paper, and the white paper really says that it is hoped that with the concerted efforts of all parties, the CE can be elected by universal suffrage in 2017. So we've tried to respond to public concerns. The white paper was published by the State Council. And the SAR government provided facts concerning economic development and social development of Hong Kong as outlined in Chapter 3 and Chapter 4. And we've studied the white paper in detail, and I think our understanding of one country, two systems and a high degree of autonomy has remained the same. And concerning the 3 concerns, in fact, we've tried to allay such concerns through various means. Mr. Kim Yun, the secretary said that information was provided for the putting together of chapters 3 and 4. But then we are most concerned about chapter 5, that the SAR government give any advice or input concerning the putting together of Chapter 5. I think I've, President, basically answered the member's question, and I've got nothing to add. Mr. Chung Hua-fong, since the publication of the white paper by the State Council, many people have adopted a biased view concerning the white paper, like what Ms. Helena Wong did. They are of the view that the central government wants to change its pledge concerning one country, two systems. They think that the central people's government wants to interfere in the internal affairs of Hong Kong. In fact, the white paper doesn't seek to look at the Hong Kong issue from another perspective. The white paper merely reiterates the central government's position. It is just that some people have distorted the basic law. Mr. Cheung, yes? Are you asking a question or are you giving a reply? I think you should be asking a question. Yes, I'm asking a question. The white paper was published on the 10th of this month in 7 languages. Over 2 weeks have lapsed since then. Has the Hong Kong SAR government received any comments from foreign governments, including the UK government, which signed the joint declaration? If no comments have been received from them, then does it mean that the content of the white paper is no different from the content of the basic law? So should this be clarified to Hong Kong people? Because there are people who are trying to stir up trouble and they are trying to mislead the people of Hong Kong. Order, please. Secretary, please give a reply. Both the basic law and the white the white paper are documents published by the state. And of course, we need to further promote the basic law. If we have people in Hong Kong or outside Hong Kong, including consuls, foreign consuls in Hong Kong, if they have inquiries concerning one country, two systems and a high degree of autonomy, we are of course willing to answer those inquiries. And concerning the question raised by Mr. Cheung, as of today, we haven't received such complaints or inquiries. 10 more members would like to ask questions on this question, but we've spent about 24 minutes on this question, and so we have to move on. Question 4.
Mr. Chan Chi-chuen, thank you, President. It has been reported that the International Christian School, ICS, requests its teaching staff and job applicants to sign a declaration entitled Standards of Biblical Ethics and Integrity to undertake that they will make themselves role models by not engaging in any form of homosexual behavior, etc., and contravention of which may lead to dismissal. I have received complaints that such a practice of ICS has allegedly discriminated against people of different sexual orientations and alternate gender identity. The Education Bureau indicated in February this year that it had reminded ICS that in formulating and reviewing its policies, reference should be made to the EDB Circular No. 33, 2003, the Principle of Equal Opportunities, and the Code of Practice Against Discrimination in Employment on the ground of sexual orientation compiled by the government. According to some media reports in early March this year, the Administration and Recruitment Coordinator of ICS indicated in response to media inquiries that the school had the right to uphold its beliefs, which included not allowing homosexuals or people of alternate gender identity to be their teaching staff. In this connection, will the government inform this Council A whether EDB has found that if ICS, after being reminded by EDB, has contravened the aforesaid circular and code of practice, if it has found that ICS has contravened them, of the follow-up actions to ensure that the employees of the school who are sexual minorities, if any, are being treated fairly, and 2, given that at present quite a number of schools in Hong Kong are run by school sponsoring bodies with a religious background, for example, Christian and Catholic bodies, whether such schools can dismiss or refuse to employ teaching staff of different sexual orientations and alternate gender identity on the ground that they run the school in accordance with their religious beliefs. Secretary for Education. President, the Education Bureau has all along attached great importance to the creation of a harmonious school culture under which all are equal and does not tolerate discrimination of any kind in schools. Through circulars, guidelines on school administration, and daily communication with schools, the Education Bureau reminds schools to observe the principle of equal opportunities and to avoid any form of discrimination apart from compliance with all the anti-discrimination ordinances when formulating and reviewing their school policies. Moreover, we have invited the Equal Opportunities Commission, EOC, and the Constitutional and Mainland Affairs Bureau to deliver thematic talks to various school stakeholders, including school managers, principals, and teachers. In these talks, relevant legislation and codes of practice, including the Sex Discrimination Ordinance, Disability Discrimination Ordinance, Family Status Discrimination Ordinance, Race Discrimination Ordinance, and the Code of Practice Against Discrimination in Employment on the ground of sexual orientation are introduced. Regarding the case mentioned in the question, the Education Bureau has reminded the school that in formulating and reviewing its policies, reference should be made to the Education Bureau circular on the principle of equal opportunities and the Code of Practice Against Discrimination in Employment on the ground of sexual orientation. The school has promised to evaluate the relevant policies and measures and is consulting the stakeholders. The Education Bureau will render appropriate support to the school when necessary. The existing 4 anti-discrimination ordinances deal with discrimination on the grounds of sex, disability, family status, and race. Schools have to comply with the provisions in these ordinances. The Code of Practice against discrimination in employment on the ground of sexual orientation seeks to eliminate discriminatory practices in employment and promote equal employment opportunities among all persons, irrespective of their sexual orientation. It is up to the school concerned to decide if it wishes to adopt the code on a voluntary basis. The issue raised in the question involves competing values and policy objectives. The administration must allow sufficient time and space for the community to continue the discussion. 2. The Education Bureau has reminded schools that to observe impartiality and safeguard interests, they should establish an open, fair, transparent, and competitive appointment system, as well as set up guidelines and formal procedures governing the appointment of staff. In all cases, schools should ensure that the conditions and terms of appointment are in strict compliance with the anti-discrimination ordinances. Schools are also required to observe the codes of practice on employment in respect of various anti-discrimination ordinances issued by the EOC. Also, the Education Bureau encourages schools to comply with the Code of Practice against discrimination in employment on the ground of sexual orientation compiled by the government. When terminating the service of staff, schools are required to comply with all the employment-related rules and regulations under the prevailing ordinances and legislation. As for aided schools, they should ensure that the relevant rules and procedures laid down in the Codes of Aid are observed. Mr. Chan Chi-chuen. Thank you, President. I thank the Education Bureau for pointing out clearly that discrimination on the ground of sexual orientation should not be allowed in schools. If you force teaching staff to admit that they are homosexuals, this should not be tolerated. But the Secretary has not actually answered my first question. I asked whether there is any follow-up action, because the school has already indicated, as I have said in the question, that they are going to uphold its beliefs, which included not allowing homosexuals or people of alternate gender identity to be their teaching staff. And according to the Secretary, the Code of Practice in employment is voluntary in nature. You have advised them, and they are not going to heed your advice. What is your follow-up action? Or are you going to just give up at this stage, and you are saying that you can do nothing more? Secretary, President, I thank Mr. Chan Chi-chuen for his question. I've set out in the main reply the premise that we have. There are 4 anti-discrimination ordinances, and we have codes of practice. And also there are certain requirements and procedures in the Codes of Aid. We have contacted the school in question. The school has promised to review the relevant rules with stakeholders. All of these are part of the relevant mechanism. The EOC has been very proactive in the case. They have taken follow-up action with the school. So what I can say to the member is that the school is now in the process of responding to the issues. So you have reviewed the situation, you have reminded them. So what kind of review are you referring to? And they are not going to follow the advice. Secretary, we have 4 ordinances and relevant codes of practice, and the EOC is going to provide relevant services on conciliation if it's judged that they have violated the relevant ordinances and codes of practice, then according to the Education Ordinance, the Permanent Secretary can take suitable action if such ordinances or rules and regulations are breached. Mr. Gary Fang, schools are public public organizations. There is not a missionary school. Whether a teacher is good is judged on the ability and capability of the staff, not because not based on the sexual orientation of the teaching staff. Would the Education Bureau agree that sexual orientation or the sex identity should not be an important factor in hiring teaching staff by schools? Secretary, as I've stressed, we want the school environment and the school sponsoring body would adhere to the spirit behind the 4 ordinances, and schools should be governed in accordance with the spirit of the ordinances. And there are other sources of reference material for the schools. And of course, each school sponsoring body has its own vision and mission. In this regard, in this particular area, we have had a lot of discussion in the community. At present, this is being promoted through a code of practice, and we respect different views and considerations. If the legislation or the relevant codes of practice are breached, we have an mechanism to take enforcement action, and we can take action according to the Education Ordinance. Well, it's said that the code of practice is voluntary in nature. I want to ask the Secretary the stance of the Bureau. I asked whether schools should consider the sexual orientation as an important factor in the recruitment of teaching staff. Secretary, I've stressed that under all circumstances, all the requirements for recruitment should fully in compliance with the 4 anti-discrimination ordinances and all the codes of practice issued by the EOC under the 4 ordinances. If there are breaches of these, we can handle the issue in accordance with our mechanism. And if there's a breach, we can also impose sanctions. And so I can say in my reply that we do not allow unfair policies and practices in schools. I just want a yes or no answer. It's voluntary. It's a voluntary code of practice. Can I clarify this point? I think the Secretary has already answered your questions based on government policies. You may wish to follow up the other issues through other channels. Ms. Sito, I think the answer is clear. The Secretary has stressed that we have 4 anti-discrimination ordinances, and we don't have one on the elimination of discrimination on the ground of sexual orientation. The present code of practice is not legally binding. So schools adopting discriminatory practices cannot be dealt with by the Education Bureau. Secretary, if we don't have an anti-discrimination ordinance on this ground, you are really powerless to do anything. Would you support the enactment of such an anti-discrimination ordinance in the Executive Council? If you think that the voluntary code of practice is effective in eliminating such a discrimination, why do you not do anything about it, why do you still allow the school to continue with such a practice? If we look at the overall environment, the bigger picture, there's been a lot of discussion in the community, and we have to take into account the question of religious freedom and the mission of the school sponsoring body in question. In June, we set up a consultative body on the discrimination against sexual minorities, which would advise the government on relevant issues and strategies and measures that should be taken to eliminate such discrimination. And based on the recommendation of the consultative body, we would commission a study to find out if sexual minorities are being discriminated in Hong Kong and the form such discrimination would take. The relevant study is still going on. The findings would certainly assist the work of the consultative body on the way forward. The question has not been answered. In the first part, you seem to suggest that such practices will be regulated, but actually they are not. If you do nothing, such practices will not be regulated. Would you yourself support the enactment of such an anti-discrimination ordinance? I'm not asking about the view of your consultant. I've already set out the relevant issues. We have a good reference material, and that is the Code of Practice, which provides a good reference to schools in question. Ms. Starry, different school sponsoring bodies have different beliefs. If it's a Christian body, it's only reasonable that they want people to adhere to biblical ethics and values. If we do not allow the religious school sponsoring bodies to uphold their religious beliefs, it means that their belief is taken away. There are court cases in Canada and the US. There are Christian bodies which ask their teaching staff and students to uphold their religious beliefs. So my question for the Secretary is this: before you issue any guidelines as regards whether religious school sponsoring bodies can ask their staff to observe religious values, would you be making reference to what other countries are doing in the US and Canada, so that you would come to the finding that such a requirement is not discriminatory? Whether it's legislation or other measures, or we would make reference to the same adopted in other countries. As I've said, this is rather complicated. Some would say that we should uphold equal opportunities. Some are concerned that the consultation may affect core family values and religion. So it's not an issue unique to Hong Kong. As the member has indicated, it's a controversial issue in other countries as well. The administration must proceed with caution. We will continue to listen to people's views. We would enhance communication and then consider the way forward. My question has not been answered. Please repeat your question. The Secretary said in enacting the 4 ordinances, the administration did make reference to overseas experience. I'm saying that whether the Education Bureau would refer to overseas experience in this particular case before you issue guidelines. Oh, yes. In the process, we will make reference to the practices in other countries, and in our communication with relevant education ministers in other countries, we would all certainly make reference to their practices. Dr. Helena Wong. Here we are talking about the fact that the Code of Practice Against Discrimination in Employment on the ground of sexual orientation is not legally binding. You can issue advisory letters to the school, but the school can just ignore you. You cannot guarantee that schools in Hong Kong, in the recruitment of teaching staff, would adopt equal opportunities as a principle. So we should formally, seriously enact an ordinance on discrimination on the ground of sexual orientation. What's your question, Secretary? Secretary, this is a private school. If a school receives public funding support, then on various grounds, religious or sexual orientation, ask the new teaching staff to join a certain church or to declare that they will not become homosexuals. Can aided schools do this? Is such a requirement a violation of the principle of equal opportunities? Secretary, thank you for your question. I've said it very clearly. Should we have such a case to handle? We have a code of practice which we will ask the school to consider, and we also uphold the overall principle that schools should allow the equal opportunities. And if there's a problem, we have an existing mechanism to deal with the issues. I will have to stress that equal opportunities should be practiced in all schools, and also in recruitment. There are different needs for the different people. With the schools will have to consider the needs to employ different people, the values of the school, and it should be a system based on merit. My question has not been answered. I was asking about publicly funded schools, and there are many school sponsoring bodies with a religious background. And if in their recruitment, they do something in terms of screening of religious or sexual orientation backgrounds. How is the Bureau going to ensure equal opportunities? If the screening is done in a biased manner, there is a channel for people to lodge a complaint, or the relevant party can take the matter to the court, to the EOC, or to the Labor Tribunal. If any law is breached, then we can invoke the Codes of Aid or the Education Ordinance to do something about it. I have to stress that we respect the objectives and the vision and mission of various school sponsoring bodies. We spent more than 23.5 minutes on this. Mr. Chan Chi-chuen, I would like to request a quorum call.
第五項質詢，張議。
Question 5, Mr. Tommy Cheung. President, in September last year, the Metro Planning Committee of the Town Planning Board, TPB, approved a planning application for the conversion of an almost century-old residence at 27 Lugard Road on the Peak into a hotel with 17 rooms. Although some sections of Lugard Road are only 1.8 meter wide, the Transport Department has approved the running of 1.475 meter wide electric mini-cars on the road to carry guests, staff, service contractors and goods to and from the hotel. Some members of the public have relayed to me that Lugard Road is a highly popular hiking trail packed with visitors and hikers. They are concerned about the prospect of pedestrians and vehicles competing for road space upon the commissioning of the hotel, which will make traffic accidents more likely to occur. In this connection, will the government inform this council, 1, why the government departments concerned still supported the planning application at TBB meetings, despite objections to the application raised by the Central and Western District Council and some of its members, as well as nearby residents on grounds of traffic and environmental problems, and the fact that 96% of the public submissions received by the TPB are opposed to the application. 2, whether it has compiled statistics on the respective average numbers of pedestrians per hour on Lugard Road on Sundays, public holidays and weekdays, if it has of the numbers, whether it has studied if the pedestrian flow coupled with the vehicular traffic flow brought about by conveyance of guests, staff, service contractors and goods of the hotel upon the commissioning of the hotel will exceed the capacity of Lugard Road. If it has done the study of the findings, please. And 3, given that currently only a small number of vehicles issued with a permit are allowed to use certain road sections of Lugard Road, of the number of traffic accidents involving such vehicles on the road sections concerned in the past 3 years, whether it has studied if the casualties of traffic accidents occurring on the road sections in question will increase upon the commissioning of the hotel, if it has studied the situation of the findings. Secretary for Transport and Housing, President. According to the information of the Transport Department, TD, the section of Lugard Road, which is a public concern, is about 800 meters in length. The concerned road is for shared use by pedestrians and vehicles. It is also the only access to the properties at numbers 1 and 27 Lugard Road. No vehicles are allowed to enter the concerned road section except those which have applied and been granted permits by the TD. In the past, the TD issued a total of 5 permits concurrently to the owners and occupants for driving to and from their properties. The wider part of the road section is over 3 meters in width, and its narrowest part is almost 2 meters wide, coupled with a 0.2 meter wide gully pit on the roadside, which is quite level. Therefore, the road section is wide enough for the shared use by pedestrians and vehicles. Both pedestrians and motorists will, of course, have to give way to one another and pay attention to safety for achieving harmonious use of the road section, that is, shared use of the road section by both pedestrians and vehicles. My reply to the various parts of Mr. Tommy Cheung's question is as follows. 1. The Town Planning Board, TBB, is responsible for approving the application for the conversion of the residence at 27 Lugard Road into a hotel. Following the TBB's established procedures, the concerned government departments give advice to the TBB with respect to their respective policy portfolios and work. With respect to traffic assessment, when the TD studied the initial traffic impact assessment report submitted by the applicant, it noticed that the applicant had not proposed any vehicular traffic restrictive measures to facilitate the use of the road section by pedestrians during holidays. The TD therefore raised objection to the planning department. Subsequently, the applicant proposed no vehicular usage in the road section a certain period of time during holidays when more hikers use Lugard Road. In the remaining time period when the pedestrian flow is smaller, the hotel's mini electric car will only run a maximum of 2 round trips, that is 4 trips per hour, when necessary. Having considered various factors, the TD opined that the revised proposal had struck a balance between the need for pedestrians to use the road section and the vehicular access right of the property owner at 27 Lugard Road to use the road section. Therefore, the TD indicated no objection to the planning application to the TPB. One of the conditions for the TPB's approval to the planning application is that the applicant must submit traffic management measures to the satisfaction of the TD. The TPB has also requested the TD to discuss with the applicant the extension of prohibiting hours for logistic trips by hotel vehicles. In response to the concern of and discussion at the TPB, the TD now plans to further restrict the use of future hotel vehicles from using the road section from 9 a.m. to 7 p.m. on Saturdays, Sundays, and public holidays. The TD has informed the applicant of its proposal. Reply from the applicant is pending. As for environmental issues, according to the information provided by the Environmental Protection Department, EPD, upon studying the relevant documents of the planning application and after conducting a site inspection, the EPD considered that there would be no insurmountable environmental impact arising from the proposal. Therefore, the EPD has no in-principle objection to the planning application. Part 2 of the reply. According to TD's information, the average pedestrian flow at the concerned road section of Lugard Road from 7 a.m. to 7 p.m. is about 540 persons per hour pph on Sundays and public holidays, and about 320 pph on Saturdays. The TD now plans to further restrict the use of the future hotel vehicles from using the road section from 9 a.m. to 7 p.m. on Saturdays, Sundays, and public holidays so as to ensure pedestrian safety. As for weekdays, there are not many pedestrians on the road section, with about 110 pph on average. That is, the pedestrian flow is only 2 persons in every minute. The TD estimates that a walk along the whole road section by a pedestrian takes about 50 minutes, while a ride by the hotel vehicle takes about 6 to 7 minutes. As hotel vehicles are allowed to make at most a total of 4 trips in 2 round trips per hour on weekdays and other non-restricted periods, the TD considers that the traffic flow generated by the hotel will not have impact on the capacity of the concerned relevant road section of Lugard Road. In addition, taking into account the time required for loading and unloading, it is estimated that a pedestrian may only come upon a hotel vehicle once or twice during his walk on the whole road section. Thus, the impact on pedestrians should not be significant, and a harmonious use of the road section could be achievable. Part 3 of the reply. As advised by the police, no traffic accident has been reported on the concerned road section in the past 3 years. As mentioned in Part 1 of the reply, the time period allowing hotel vehicles to use the road section and the number of vehicle trips are subject to stringent restrictions. Thus, the TD sees no particular factors that may lead to an increase in the number of traffic accidents. Nevertheless, upon the opening of the hotel, the TD and the police will closely monitor the traffic condition of the road section and implement appropriate traffic management measures as necessary to ensure road safety. Mr. Tommy Cheung. Mr. President, I think the Secretary's reply is biased. In Part 1 of the reply, he says that the narrowest section of the road is close to 2 meters. But in my question, I say that the width is actually 1.8 meters. And the vehicles permitted would be 1.475 meter wide. And in Part 2 of his reply, he says that it seems that there will be just 2 passengers per minute on the road, and with a vehicle passing by, what is the problem, it seems. But then if you study the figures carefully, a person takes 50 minutes to walk that whole section. That means at any time on that road section there will be 30 to 40 pedestrians minimum. And the road section is 1.8 meters wide. The car measures 1.475 meters wide. He says that for a pedestrian, it takes 50 minutes to walk the section, but for a vehicle, it takes 6 to 7 minutes. So there will still be the scenario of pedestrians and vehicles competing for road space. So I wonder if you have actually studied the figures carefully, and has the TD done any experiment to verify the figures? Secretary, the figures are provided by the Transport Department, and the TD did carry out a site inspection to count the number of pedestrians. And as I said, on weekdays where pedestrian flow is less, there will be 110 pph on average. That means that any time there could be someone walking along that section. But in future, so we want to work out what is the probability of vehicles meeting pedestrians on the particular section of the road. Now, there will be restricted hours when health vehicles are not allowed to travel on the road. And then when there's a need, every hour there will be at most 2 trips. So there's a chance, the chance of pedestrians meeting the vehicles and they have to accommodate each other, that sort of possibility is low. And so with some accommodation, both parties could use the road. Your question's not been answered? Well, the TDs provided you the figures, but have they done any experiment with a vehicle passing by and pedestrians passing by at the same time? So have you done any proper experiment instead of just relying on guesses and estimates? Secretary, in the Transport Department's assessment, now, there should be many occasions when pedestrians will and the vehicle will be on the road at the same time. And also there could be accommodation, and then both parties could still use the road. Mr. Yu-chung. Thank you, President. This is a century-old residence. It will be converted into the hotel. I think it bodes well for the tourism ministry. The government should support it. Having balanced environmental protection, road safety, and other factors, whereas the administration should proceed with the approval process in reasonable and legitimate manner. Now, if in future on Saturday, Sundays, public holidays from 9 a.m. to 7 p.m., no hotel vehicles are allowed to use the road, that is posing a difficulty for the hotel. It's unfair to hotel users. It's not reasonable either. So I wonder if the administration will talk to the hotel operators and find a reasonable solution to the problem. Secretary, as I said in my main reply, in the early stage, when the proponent submitted a proposal, they did not include any road restriction or restricted use of the road, and that's why the TD raised objection to the proposal. But then the proponent subsequently proposed to limit the number of trips using the road on Saturdays, Sundays, and public holidays. And when the Town Planning Board approved the application, it's attached conditions to it. It's taken into account traffic impact, the response of local residents, and so on in coming up with such conditions. So that's why there's this arrangement for restricted hours. Mr. Yu, well, you have you make things difficult. It's not reasonable. Mr. Yu, please do not make a comment. Now, I would like to ask the Secretary whether you would talk to the hotel operator to arrive at a reasonable solution. I believe the Secretary has already stated clearly how this issue would be addressed. And you are just saying that you do not agree with the Secretary on this approach. So this is not a matter to be followed up here. Please follow up on that on other occasions. Mr. Frankie Yik. Mr. Tony Jie. Now, it's mentioned in the reply that 5 permits have been issued in the past to owners and occupants at the properties on Lugard Road. Have you done any study or analysis? Every day, how many vehicle trips are made on that road now? And after approving the conversion of the residents to hotels, what is the percentage increase in vehicle trips? Have you done any such assessment? Secretary, I do not have the information at hand. That is currently for the property at number 27 Lugard, the owner or occupants, how many vehicle trips they make each day. But we can say that we have issued 5 permits, but then there's no restriction on when the vehicle trips can be made. So there are 5 permits. Of course, depends on the needs of the owners and occupants. They may use the road. But in future, when the residence is converted into a hotel, there will be restrictions on road use during certain periods. This is to make sure that there is road safety and the road could accommodate both pedestrians and vehicles. So on Saturdays, Sundays, and public holidays, there will be no vehicle trips will be allowed from 9 a.m. to 7 p.m. And on weekdays and other periods, there is still a limit of no more than 4 vehicle trips per hour. So you can see there will be restriction on vehicular flow in future. This is to make sure that vehicles and pedestrians would not be competing for road space, and this will help to enhance road safety. Mr. Felix Chung. The TD has done an assessment that there is no problem with the traffic situation there. Now, these are electric vehicles, small vehicles that are allowed to be passed. But what if there's an emergency? What about fire or hill fire? The nearest fire station is 1 kilometer away. So when there's an emergency, it could be dealt with properly. Secretary, at any time, even now, for that particular location, if there should be a fire or other incidents, the emergency services, fire services will have to make use of that road to carry out rescue operations. But of course, the TD would not consider the fire services angle. I believe the fire services department and other relevant departments would have given their assessment to the TPB. Now, let's say in future the residence is converted into a hotel and there are restrictions imposed on road use. And I must stress that only when it's necessary, that is outside the restricted periods, when it's necessary, the hotel could make at most 4 vehicle trips per hour to and fro. It's because probably the hotel guests need to use the vehicles, or they need to make logistic trips. So it's not like they could run a shuttle service as such. No, it's not like that. That's why the TD believes that when it comes to restricting road use, we are able to maintain an adequate safety coefficient. Your question's not been answered? No, my question's not been answered. What if there is a fire? Can you handle it? Or other emergencies? Secretary, now in the approval process of the TBD would invite views from relevant government departments, so the Fire Services Department has rendered its views. I'm sure the Town Planning Board must have taken into account any fire safety concerns in considering the application. Mr. Frankie Yik, now the Environmental Protection Department says that there won't be any insurmountable environmental impact. But just now, Secretary, you mentioned there will be many restrictions on the use of the road during holidays and so on. After the property is converted into a hotel, there will be more people flow. Waste will be generated and emissions will be generated. That should be higher than that of the current level. Because from the Ming Pao report, we know that the owner knows that there's a narrow road, so very often he won't drive, he just walk. Given he knows the road is narrow, that's why. But in future, when there is additional generation of waste and emission, how come it won't have an impact on the environment? Secretary, President, when the Town Planning Board approved the application, I understand that the TPD has sought views from the Environmental Protection Department on approving the application. The TPB has imposed conditions to make sure that the environmental concerns are addressed. On sewage management or other, issues that may affect the environment, adequate steps have to be taken in future. Now, for untreated sewage, like wastewater discharged from the spa, it cannot be discharged into the streams nearby. And the hotel must make sure that the sewage is treated properly in accordance with the Relevant Water Pollution Control Ordinance. And then during construction works for the septic tank and so on, all the designs for layouts and designs for these facilities must be submitted to the Buildings Department for approval. So it's to ensure that there will be minimal environmental impact. What about solid waste? Secretary, the Environmental Protection Department has put forward various views to the Town Planning Board, and in approving the application, the Town Planning Board has requested the hotel operator to make sure that it will meet the requirements of the Environmental Department during the construction stage and the future operation. Mr. Wong Kwok-kin. Well, when I have time, I would like to take a walk there with my wife. I know that's a popular trail. In the Secretary's reply, I think you've tried to cut corners. You haven't taken account the pedestrian flow between 9 a.m. From 7 a.m. to 9 a.m. That's the time when there will be the most morning walkers. And can you ask the hotel to use tricycles or rickshaws instead? Because that's more environmentally friendly. It will address the traffic issue. And actually, more visitors will be attracted to go and visit the Lugard Road heritage. And then they could take a trip down memory lane to relive Hong Kong's history. Now, if rickshaws could be used to enhance the special characteristic of a hotel, that can be considered. But anyway, this is not a condition taking account when the TD is asked to make an assessment of the traffic impact. So the TD has actually considered the impact of the use of electric vehicles instead. Now, as mentioned, at the early stage of the application, the proponent did not propose any restrictions on road use, but then the TD raised an objection, and after that the applicant proposed that during certain periods on weekends and public holidays, the mini electric vehicles would not be used. As I said at the beginning, initially they suggested the restricted up periods to be from 10 a.m. to 6 p.m. But then the Transport Department has studied the relevant figures and the pedestrian flow during those days, and it's proposed further restrictions. So the restrictions will be from 9 a.m. to 7 p.m. Before 9 a.m., the TDs also got figures. And we find that the pedestrian flow during that period is more or less the same as that during weekdays when there's a lower pedestrian flow. Mr. Raymond Chen, call for quorum, please.
The last oral question, Honorable Hon Kwok-kin. Thank you, Mr. President. The Chief Executive stated in his 2014 policy address that strategic planning would be made for building a new acute general hospital at the Kai-Tak development area, the Kai-Tak Hospital for short. It has been reported that according to the latest assessment, the completion date of the Kai-Tak Hospital, which the authorities originally forecast to be 2020 at the earliest, may be deferred to 2023. In this connection, will the government inform this council whether it knows, first, if the hospital authority HA has assessed, based on the current progress, whether the surface planning and technical feasibility study for the Kai-Tak Hospital can be completed within this year as scheduled, the latest progress of the surface planning, whether, based on the authority's latest assessment, the hospital can be completed in 2020. If so, of the detailed timetable and expected time for submission of funding applications to the Legislative Council, if not the details of the reasons for that. And second, if HA has assessed the impacts of the failure to complete the Kai-Tak Hospital in 2020 on the redevelopment of the Queen Elizabeth Hospital, on the service quality of the Hong Kong Children's Hospital upon commissioning, and on the planning of the overall healthcare services in Kowloon, of HA's measures to mitigate such impacts. Secretary for Food and Health, Mr. President, to meet the healthcare service demand of Hong Kong in the long run, we have reserved a site in the Kai-Tak Development (KTD) area for the development of healthcare facilities, including the Hong Kong Children's Hospital (HKH), which is under construction, and the proposed acute general hospital. With the funding approval of the FC of the LegCo in June 2013, the construction of the HKCH has already commenced. To cater for the long-term overall demand for healthcare services in Kowloon, we have asked the HA to conduct the relevant strategic planning and studies with a view to implementing the plan of constructing an acute general hospital of a larger scale in the KTD area as soon as possible. My reply to the various parts of the question is as follows. First, THA is conducting the relevant strategic planning and studies on the construction of a new acute general hospital in the KTD area in order to gauge the healthcare service needs of Kowloon and the Kai-Tak area. Technical assessment and analysis of clinical needs are also carried out to ensure that the provision of healthcare services will cope with the development and demographic changes of the area. The proposed hospital will provide clinical services of major specialties, including accident and emergency service. The planning and technical feasibility study for the construction of the new hospital are expected to be completed this year. As the relevant studies are still in progress, the completion date of the proposed general hospital has yet to be finalized. Upon the completion of the planning work, HA can formulate a more concrete timetable for the hospital development project. Will then seek funding approval in accordance with the established procedures so as to implement the construction plan of the general hospital in the KTD area as soon as possible. Second, the HA plans to develop a hospital group in Kai-Tak, which can provide holistic healthcare services. The group of hospitals will include a pediatric hospital and a major general acute hospital with a neuroscience center. The groundbreaking ceremony of the HACH was held on the 25th of February 2014, and the construction of the Hong Kong CH is now in full swing. The hospital is scheduled for completion in 2017 and will commence service in phases starting from 2018. The HKCH will be the first hospital commencing service in the KTD area. During this initial stage of operation, the HKCH will be supported by other general hospitals. In the long run, its operation mode will be different from the pediatric departments of conventional general hospitals. The HKCH will focus on handling complex and rare pediatric cases which require multidisciplinary management. Other public hospitals will continue to provide emergency care, general pediatric specialty care, and community care services for pediatric patients, while complex cases such as children's cancer, cardiological, and advanced nephrological cases will be referred to the HKCH. The HKCH will work in close collaboration with pediatric departments and relevant specialties of various hospital clusters to establish a coordinated and coherent pediatric service network that provides patients with the most suitable care. HA is planning for the future operation of the HKCH, as well as its coordination and support arrangements with other hospitals. On the other hand, HA is reviewing and assessing the demand for and supply of healthcare services in Kowloon, as well as developing the clinical service plans of the Kowloon Central Cluster and the Kowloon East Cluster. During the planning process, the long-term healthcare demand of local residents will be considered, and the direction of future service development of hospitals in the clusters, including the Queen Elizabeth Hospital, and their coordination with other hospitals will also be worked out according to the demand projection and service plans. The review and the service plans are expected to be completed within this year. HA will continue to keep in close view the healthcare service needs in the area and deploy resources appropriately to ensure the provision of appropriate healthcare services for the local community. The redevelopment of QEH is still in the preliminary planning conceptual stage, and the administration has yet to finalize a plan. Thank you. Mr. Wong Kwok-kin. Mr. President, for the reply from the administration, it is indeed regrettable. The Secretary can't even give an expected timetable. I think it is clear. For a long time, Wong Tai Sin lacks a large-scale general acute hospital. Residents have been expecting one for a long time. But it appears that from the reply of the Secretary, the residents are being disappointed once again because we see no date for the completion of the Kai Tak Hospital. Before the completion of the Kai Tak Hospital, I want to know if there are any mitigatory measures in the medium term or the long term. Say, for example, providing emergency services at the Our Lady of Myrna Hospital. Secretary, Mr. President, I would like to thank Mr. Wong for his question. For Wong Tai Sin, we have Kwong Wai Hospital, QEH, as well as the United Christian Hospital providing emergency services. And in fact, at the above-mentioned three hospitals, support is being given to the hospital needs of Wong Tai Sin. The headquarters of the HA have also talked to the FSD, and we have a communication channel and a review mechanism in relation to the routing of the ambulances, so as to make sure that for residents living in Wong Tai Sin, if they have any urgent needs, they will be well taken care of. I understand that within Wong Tai Sin, there is always this aspiration. There is the hope that at either the Our Lady of Myrna Hospital or another hospital within the cluster or the district, there should be the A&E department. But from a professional point of view, A&E department specialists have also investigated into the matter. We need more comprehensive support services before we can have a general acute hospital so as to run an A&E department. Therefore, for the time being, we have no plan to create an A&E department at Our Lady of Myrna Hospital. Thank you. Mr. Lee Kwok Lun. Two promises made. In 2018, the Hong Kong Children's Hospital. In 2023, Kai Tak Hospital. Of course, for the QEH, no plan has been confirmed yet. Through you, Mr. President, I would like to ask the Secretary this question. You are sort of giving us two dated checks. We know that one nurse is looking after 11 patients, according to a survey done in May. Now you are making further undertakings. Now the HA hasn't got any manpower benchmarks. Internationally, we should have one nurse taking care of 6 patients. Now, in 2018, Hong Kong CH, 2023 or 2020, Kai Tak Hospital, they are new facilities. If you haven't got any benchmarks, how can you be sure that there will be sufficient nurses? If you do have a benchmark for manpower planning, how many more nurses would you need before you can honor your undertaking to open the 2 new hospitals? If you haven't got benchmarks, how are you going to project the manpower needed? Let me sort of clarify 2 points. For the pediatric hospital, that is the Hong Kong CH, it is right to point out that it will be completed and commissioned in 2018. But then for Kai Tak Hospital, for the general hospital in Kai Tak, we at this stage have not come up with a date of completion and commissioning. The main reason has already been given just now. This is because we are still at the stage of planning. Therefore, at this stage, we are not in a position to have a firm date of completion from the HA. Professor Lee is concerned about manpower. The Bureau and the HA have been aware of the following issue, that is, with the aging of the population and with the population growth. We do understand that in the public hospitals, we face a problem, and it is also getting worse, and that's in relation to the workload. For our health professionals in all disciplines, we all suffer from a shortage. For nursing staff, yesterday, the HA has come up with a reply. It points out that with more funding from the government, the HA has plans to do the following in the short term. That is, 1,600 nurses will be employed to fill the vacancies and to ease the problem of manpower shortage. If the market has the relevant supply, then we hope that we can recruit 300 more nurses so as to prepare for the peak in the demand for our service towards the end of this year. Looking back for the past few years, yes, indeed, there was an increase in the workload, but then in the year 2012, in the year 2011-2012, we had 20,900 nurses. Nowadays, we have got 25,600 nurses. So there has been an increase. For the long term, we have already got a steering committee to review healthcare manpower. Within this year, the review committee will come up with a conclusion and recommendations. There will be specific recommendations to help us in the long run so that we can face the problem that will crop up in the coming 5 to 6 years' time. That is, there will be an expansion in the capacity of our hospitals. Your question hasn't been answered? Not answered, but it's a simple question. If you haven't got a benchmark, how can you be sure that you know how many nurses to employ and whether you've got enough nurses? Secretary, I have noted Mr. Chen. I will wait for the Secretary to finish first. Thank you, Mr. President. Thank you, Mr. Chen. We know that for the nursing sector, in particular the nursing unions, they've always wanted to have an objective and quantifiable international manpower benchmark. We beg to differ. I mean, in terms of the perspective of the HA, because internationally there isn't a broad consensus as to a benchmark. Different countries have different healthcare systems and they have got different healthcare financing models. Therefore, we do not think that it is right to apply one single manpower benchmark across the board. The HA has been looking at the different needs of different disciplines so as to plan for the nursing establishment. Mr. Albert Chen, please ring the bell to form a quorum. Quorum count, please.
方剛議員，請你提出你嘅補充質詢。
Mr. Vincent Fang, please ask your question. Mr. President, with the aging of the population and with more serious conditions which were incurable getting treatments, and with the advancement of medical technology, it means that the administration has to spend more financial resources to retain manpower and to enhance the service standards. So with so many different claims on our funding, and in fact, every year we are increasing the subvention to the HA up to $100 million, $1 billion. But then it is just a few percentage points. So I want to know, upon completion of the new facilities, will there be an increase in healthcare funding? And can the government tell us by how much will the funding be increased? Secretary, I'm also very concerned about the point raised by Mr. Fang. Of course, there are two principles. First of all, the government will provide funding to build a new facility, including new hospitals, would imply that we have to earmark resources to fund the recurrent expenditure. And at the same time, we have resource allocation mechanisms. We have to look at the economic growth rate prevailing, and we have to look at the public finances of the government. So in brief terms, when we build any new hospitals, we have to prepare for the corresponding increase in recurrent expenditure that would call for. Mr. Chen Kam-lam. Mr. President, I think the original plan was that it is hoped that in year 2020, Kata Hospital will be completed. Now there will be a strategic study and a technical feasibility study. And then we haven't been given a concrete timetable. Of course, it is disappointing. And in the coming years, there will be more people moving to live in Kai-Tak development area. There are already two public housing estates with population intake for Kowloon East Cluster and Kowloon Central Cluster. It means that there is a lot of pressure in terms of their workload. So has the administration planned for anything to cope with the increase in workload? Secretary, let me clarify once again. For the construction of a hospital, which is of larger scale and of the nature of a general acute hospital, well, it is in this year's policy address that the CE first proposed the idea. At the time the idea was proposed, we have already made it clear that for any general large-scale acute hospital, we must carry out a strategic planning. And this is true for all large hospitals. So in the CE's policy address, he, for the first time, proposed a hospital at Kai-Tak development area, and therefore we have to come up with a strategic planning. And that would be followed by technical feasibility studies. Well, this is true for all projects. Generally speaking, we would not name a specific timetable for completion. This is because it is only when we have already gone through the RAE, that is the resource allocation exercise, before we can come up with a more specific timetable of completion. Therefore, we haven't named a date for completion. In the community, and maybe within the hospitals. Many people have talked about such a date, but it doesn't mean that we have got such a date in mind. Mr. Chen Kam-lam is right to say that with the population on Kai Tak development area growing, so we have to look at the Kowloon Central Cluster, namely QH, UCH, and Kwong Wai Hospital. We have to make sure that adequate service can be provided to this area, which has seen a growth in population. Dr. Helena Wong. Thank you, Mr. President. For the Kai Tak development area with Kai Ching Estate and Tak Long Estate, we have got over 30,000 people living there. Population intake has been completed. Be it healthcare services or education services, I'm afraid that the government's planning has been lagging behind. Now, Secretary, you haven't been able to name a timetable. You said that the study will only be completed towards the end of this year. Would you consider expediting the work? That is, for the large general acute hospital at Kai Tak, can you not advance the work, expedite the work? Otherwise, the 30,000 people living in Kai Tak and with other people gradually moving in, it means that the workload on the existing hospitals will increase, and yet they will be made to wait for 10 years or more before they get a hospital. Secretary, I understand that hospitals are concerned about the case of Kai Tak as well as Wong Tai Sin, which is near to the Kai Tak development area, in relation to the healthcare needs. When we have a large project, including the building of a large hospital, well, the planning has to go through certain procedures, and we can't take the matter lightly. But then I do share your view. That is, we would like to compress the planning process and have it completed ASAP. But I can tell you that for such a large hospital, the last time that Hong Kong built a hospital with more than 1,000 beds took place 10-20 years ago. So for such a large-scale hospital, which has to be modern, even if we have a firm idea and even with the funding from the electrical, I think it will take 6 years' time to complete the construction. We've spent almost 23 minutes for this question. That's it for oral questions today.
President,
President, can you please